Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. You know what? Right now, I really could be dancing because I am so happy with the court victory that we got yesterday against Trump's effort to rig the 2026 midterm. Wow. Wow, 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 wow. A shout and an applause for that huge, huge, huge victory. All right, so I want to walk you through what all this means, what exactly happened, and where we are going next. It is extremely important that you get this from an African-American civil rights lawyer who not only knows what happened legally, but what it means for us as a people. As a people. You can't get that from those other channels because those other channels are white channels for the most part. And if something else happens with the Voting Rights Act, it's not going to impact them, not one bit. The folks over at Midas Touch or Legal AF or Democracy Docket, the folks over there will not be impacted, not one iota, if SCOTUS guts the Voting Rights Act tomorrow. And nothing remains of it because they are white. They have never been the subject of voter disenfranchisement. They've never been the target of voter suppression. So you need to hear this stuff from African-American people who know what they're talking about and who love the African-American community. I am an African-American, number one. And two, I am a civil rights lawyer. And three, I love my people. So I'm going to bring a perspective to you that you're not going to get otherwise. So let's go to another screen and let's walk through this. We're going to read through some notes that I've made, and then we're going to read through a little bit of the court's opinion from yesterday. All right? Very important. I want you to understand this stuff. And I believe you can understand it. I absolutely believe that you can understand it because I do my best to try to break it down. All right? So, at Trump's urging and after a DOJ threat letter, and that letter is really important, Texas Republicans passed a new mid-decade congressional map designed to add about 5 GOP-leaning seats for the 2026 midterms. All right, that's what we've been dealing with for the last few months. So the Texas legislature drew up a new map that heavily disfavored African Americans and Latino voters. All right? Civil rights groups sued, arguing that the 2025 map, the new map, racially gerrymandered districts and violated Section 2 of the Voting Rights Act and the Equal Protection Clause by diluting Black and Latino voting strength. Racial gerrymandering. And by the way, shout out to the NAACP who helped litigate this case, right? I know a lot of folks try to say the NAACP is no longer doing work for the African-American people. They're fighting on behalf of everybody else. Not so. Not so. They're also the lead litigators who are trying to save Section 2 of the Voting Rights Act. All right, so shout out to the NAACP. So once Texas released that new map, the NAACP and other litigators joined forces to fight this new map. All right, let's go on. Because the voting case challenges the new map, a 3-judge district court panel was required to hear it under 28 U.S.C. Section 2284. So that's why it was in the federal court, the lower district court, but 3 judges had to hear it. Just to give the appearance that the hearing was fair. That's why Congress mandated that and why it is a federal requirement. If you challenge a voting district map, 3 judges will hear that case instead of just 1. In this instance, of the 3 judges, 2 were appointed by Republicans, one of them a Trump appointee, and another one an Obama appointee. So the 3 judges, 2 Republicans, but it was the Obama appointee and the Trump appointee who gave us the 2-1 majority victory in this case. All right, so they heard the case in a 2-1 opinion. The 3-judge panel held that the plaintiffs are likely to prove that Texas racially gerrymandered the 2025 map. Now, let me explain why before I go any further. Why are they likely to prove it? Because of that letter I told you about just a second ago from the DOJ, writing where the DOJ basically wrote the state of Texas and said that there were 4 districts that had been racially gerrymandered and they need to fix that. So in order to fix that, basically they had to essentially focus on race to fix it, because the 4 districts that the DOJ letter said had been racially gerrymandered created majority-minority voting districts. So in order to reverse it, Texas had to focus on race. So that is basically an admission that this was all about race. All right, so this was, as the court said, this was racial gerrymandering. All right, so the panel also preliminarily enjoined the new map and ordered Texas to use the 2021 map for the 2026 election. That is huge. So they said because the plaintiffs are likely to be able to prove that this was racial gerrymandering that Texas did to create this new map, the court followed that up by preliminarily enjoining, meaning stopping Texas from using that racially gerrymandered map. All right. Then the Texas Attorney General Ken Paxton filed a notice of appeal. The appeal goes directly to the U.S. Supreme Court under 28 U.S.C. Section 1253, bypassing the Fifth Circuit. So whenever plaintiffs challenge a voting map, then that case goes to SCOTUS on appeal. So that's why it is not going from the lower court to the Fifth Circuit, which is ordinarily what would happen to the Fifth Circuit Court of Appeals. No, it's going all the way to SCOTUS. And the Attorney General for the state of Texas, Ken Paxton, has already filed that notice of appeal. All right. So let me pull that up and show it to you. Here it is. The state of Texas notice of appeal. Notice is hereby given that defendants, the state of Texas, Greg Abbott, in his official capacity as governor of Texas, Jane Nelson, in her official capacity as a Secretary of State, and Dave Nelson in his official capacity as Deputy Secretary of State, collectively hereby appealed this court's November 18, 2025 order granting a preliminary injunction to the United States Supreme Court. This appeal is taken pursuant to 28 U.S.C. Section 1253. All right, so that is the notice of appeal that Ken Paxton signed and filed on yesterday. All right, so let's go back over and continue reading what has happened in this case. All right. So here we go. Texas Attorney General Ken Paxton filed a notice of appeal. The appeal goes directly to the U.S. Supreme Court under 28 U.S.C. Section 1253, bypassing the Fifth Circuit. All right, now let's continue reading. Texas may also ask the Supreme Court to stay the 3-judge panel's preliminary injunction so the state can attempt to use the challenged map during appeal. Now, that's what could happen in this case. So, our victory may not be long-term, and it may not be enough. I don't know. Because they're able to go to SCOTUS. And in addition to filing that notice of appeal, Texas can also ask SCOTUS to issue an administrative stay. And if Texas did that, that application or request for an administrative stay would go to none other than Sam Alito, Justice Alito, who is very, very favorable to Trump and MAGA. Very favorable. So he could himself grant the administrative stay, and then as far as the regular stay is concerned, then go to the full court on that. Or, he may not. I don't know. We don't know, but this is something that could happen. Now, as of right now, as far as I could tell, I don't see where Texas has requested an administrative stay yet, but I fully suspect that they will. And ask SCOTUS, essentially, to let them use that new map. All right? Now, I want to read some of the case because some of what the court wrote is very instructive for us African Americans, and I want to highlight those particular parts of the court's order. Okay? So let's go back over. So we see here memorandum opinion in order granting preliminary injunction. All right? In August 2025, the state of Texas enacted a new electoral map to govern elections for the U.S. House of Representatives 2025 map, claiming that the 2025 map is racially discriminatory. 6 groups of plaintiffs, the plaintiff groups, asked the court to preliminarily enjoin the state from using the 2025 map for the 2026 election. For the reasons explained below, the court preliminarily enjoins the state from using the 2025 map. Yea, again. The court orders that the 2026 congressional election in Texas shall proceed under the map that the Texas legislature enacted in 2021, the 2021 map. That is a huge victory. And it is something that Trump will be extremely unhappy about because he put all this, he set all this in motion. Now, it was interesting that the court starts with something that Chief Justice John Roberts said. All right? And here it is. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. So they gave Chief Justice John Roberts his language back to him. I thought that was interesting. So the public perception of this case is that it's about politics. To be sure, politics played a role in drawing the 2025 map. But it was much more than just politics. Substantial evidence shows that Texas racially gerrymandered the 2025 map. You can do political gerrymandering, Supreme Court said, but you cannot do racial gerrymandering. pursuant to or in violation of Section 2 of the Voting Rights Act. I've been doing multiple videos on the importance of Section 2 of the Voting Rights Act and the fact that Clarence Thomas has been trying to gut it for over 30 years, and the fact that Section 5 of the Voting Rights Act has already been eliminated. So Section 2 is the last remaining section that has the most bite to protect our voting strength. Earlier this year, President Trump began urging Texas to redraw its U.S. House map to create 5 additional Republican seats. Lawmakers reportedly met that request to redistrict on purely partisan grounds with apprehension. When the governor announced his intent to call a special legislative session, he didn't even place redistricting on the legislative agenda. But when the Trump administration reframed its request as a demand to redistrict congressional seats based on their racial makeup, Texas lawmakers immediately jumped on board. So they started out with racial gerrymandering on their minds, is what the court is saying. On July 7th, Harmit Dillon, the head of the Civil Rights Division at the Department of Justice, sent a letter to the governor and attorney general of Texas, making the legally incorrect assertion that 4 congressional districts in Texas were unconstitutional because they were coalition districts, majority non-white districts in which no single racial group constituted a 50% majority. In the letter, DOJ threatened legal action if Texas didn't immediately dismantle and redraw these districts, a threat based entirely on their racial makeup, right? I explained that to you in the beginning. That's why this letter is so important, because the letter instructs Texas to deal with those districts, those coalition districts, on the basis of race, which is a huge red flag that this is racial gerrymandering. In the letter, DOJ threatened legal action if Texas didn't immediately dismantle and redraw these districts, a threat based entirely on their racial makeup. Notably, the DOJ letter targeted only majority non-white districts. Any mention of majority white Democrat districts, which DOJ presumably would have also targeted if its aims were partisan rather than racial, was conspicuously absent. So it was clear what this was all about, the court is saying. 2 days later, citing the DOJ letter, the governor added redistricting to the special sessions legislative agenda. In doing so, and by the way, Texas, when it drew that 2021 map, Texas said it was not racial gerrymandering. But the DOJ said, no, it was. Anyway, in doing so, the governor explicitly directed the legislature to draw a new U.S. House map to resolve DOJ's concerns. In other words, the governor explicitly directed the legislature to redistrict based on race. In press appearances, the governor plainly and expressly disavowed any partisan objective and instead repeatedly stated that his goal was to eliminate coalition districts and create new majority Hispanic districts. I mean, they are on the record admitting that this was about racial gerrymandering. The legislature adopted those racial objectives. The redistricting bill's sponsors made numerous statements suggesting that they had intentionally manipulated the district's lines to create more majority Hispanic and majority Black districts. The bill's sponsors' statements suggest they adopted those changes because such a map would be an easier sell than a purely partisan one. The Speaker of the House also issued a press release celebrating that the bill satisfactorily addressed DOJ's concerns. Other high-ranking legislators stated in media interviews that the legislature had redistricted not for the political goal of appeasing President Trump, nor of gaining 5 Republican U.S. House seats, but to achieve DOJ's racial goal of eliminating coalition districts. I mean, they literally admitted it. So this was an easy one for the court. Easy. Now, I want to continue reading here because I want you to see how important Section 2 is of the Voting Rights Act. Okay? All right. So this says, here's some background. The law governing racial discrimination challenges 2 redistricting plans. Because racial discrimination in voting cannot coexist with democratic self-government, federal law provides various avenues for challenging an electoral map as racially discriminatory. There are at least 3 avenues to do so. Number 1, racial gerrymandering. First, a plaintiff can bring a racial gerrymandering claim under the 14th and 15th Amendments. Right? The 14th Amendment, as we know, has the Equal Protection Clause in it. And the 15th Amendment it states that the rights basically of blacks the right to vote cannot be abridged. All right. A racial gerrymandering claim alleges that the state, without sufficient justification, has separated its citizens into different voting districts on the basis of race. The plaintiff must prove that the state subordinated race-neutral districting criteria to racial considerations, such that race was the predominant factor motivating the legislature's decision to place a significant number of voters within or without a particular district. So you're just trying to create districts based on race. And you're going to see why Section 2 is so important in just a second, all right? So this is one way to do it. The other way is intentional vote dilution. Second, a plaintiff can bring an intentional vote dilution claim, which is analytically distinct from a racial gerrymandering claim and follows a different analysis. All right. In an intent dilution claim, it alleges that the state has enacted a particular voting scheme as a purposeful device to minimize or cancel out the voting potential of racial or ethnic minorities. Intentional vote dilution violates both the Constitution and Section 2 of the Voting Rights Act. To prevail on an intentional vote dilution claim, the plaintiff must show that the state's districting plan has the purpose and effect. Purpose and effect. Purpose means intent. So it had the intent and the effect, the results of diluting the minority vote. Keep reading with me. Effects-based vote dilution, Gingell's claims. Both of the first 2 claims require, watch this, the plaintiff to prove that the legislature actually with some sort of unlawful intent. That is difficult to prove that the legislature had the intent of racially gerrymandering a voting district. Unless you got a letter from the DOJ instructing them to do so, but most of the time you don't get that. All right, so to supplement these intent-based causes of action, listen carefully, Congress amended the Voting Rights Act, Section 2, to enable plaintiffs to challenge electoral maps based on their racially dilutive effects alone. So you don't have to prove intent under the voting rights, under Section 2 of the Voting Rights Act, just effect. And when Congress changed the Voting Rights Act, Section 2, to achieve that, it was a brutal fight in Congress. I remember it very well. And, God, I forgot the particular senator. I see his face. He was the one who kind of led the effort, okay? And to get this language in there, because it was just really hard to prove these racial gerrymandering cases based on intent or purpose and effect. All right? So they fought it out in Congress and came up with specific language that is now a part of the Voting Rights Act, Section 2, that makes it easier. That's why getting rid of it is so important to MAGA, and not getting rid of it is so important to us African Americans especially. All right, let's go back over. So the amended Section 2. To prevail on an effects-based vote dilution claim under Section 2, a plaintiff must satisfy what are known as the three Gingell's preconditions. The first and second Gingell's preconditions are both defined with reference to a minority group. Precondition number 1 asks whether a minority group is sufficiently large and geographically compact to constitute a majority in a reasonably configured district that the legislature could have drawn, while precondition 2 asks whether the minority group is politically cohesive. So, is the minority group, is it compact enough in a reasonably drawn district, not one that looks like a snake all the way across the state, but is compact? And are they, for the most part, politically cohesive? So are they mostly, in this case, Democrat? If yes, then you meet the first two Gingell's preconditions. Gingell's is just the name of a case where they came up with these conditions. So that's all Gingell's is. All right. Now, critical to this case, the law governing how to define the requisite minority group has shifted over time from 1988 to 2024. A Fifth Circuit case, Campos versus City of Baytown, permitted Gingell's claimants to define the minority group as a coalition of two or more cases. All right, we don't have to go into coalition districts. I wanted you to see very simply that because of the change to Section 2 of the Voting Rights Act, it no longer requires plaintiffs to prove that very, very, very difficult standard of intent and effect. Now, under the current Section 2, all one has to do is prove effect, meaning just be able to show the results of the voting district resulted in racial gerrymandering. You don't have to try to put forth any evidence to show that the legislature intended for there to be racial gerrymandering, because that can be very difficult. Except, again, in a situation where the DOJ instructed them to do so, which is the case here. But that is rare. So my point is, keeping Section 2 of the Voting Rights Act is very important. But I am very concerned that SCOTUS is about to gut it, or at least weaken it in some way. So this case is important in terms of the midterm elections that are coming up at the end of 2026. But a very important side note is whether or not Section 2 will be gutted by SCOTUS. If so, then that case could potentially retroactively give Texas the win and Trump the win that they want in the first place. Because it is under Section 2, right? And the 14th Amendment Equal Protection Clause that this case is being analyzed under. And it's the reason why the court said that the plaintiffs are likely able to show racial gerrymandering. So they issued the preliminary injunction. So as of right now, Texas cannot use the new map. It must use a 2021 map that they had already drawn. But do remember, Texas can, if it hasn't already, file an application for an administrative stay and ask the court to just basically stop this 3-judge panel's preliminary injunction so that they can use the 2025 new map. All right. So that is what's going on, what has happened, and what could happen in this extremely important case. All right. I am Reverend Civil Rights Attorney Augustus Corbett. Thank you for watching this video, and stay woke.